Thanks for coming to the intimate space here. This is my guest today. This is Jeff Lamberti, and he's an attorney that we've worked with. We get to work with attorneys all across the state of Iowa, and of all the attorneys we've worked with, this guy has solved more problems for me than than anything. And I always say he's got the smoothest, coolest demeanor when it comes to an argumentative client of just calming them down somehow. I rev them up, and he calms them down. So if you guys don't know Jeff, welcome, Jeff. He was also State Senate, and part of the owner of the Barnstormers. Is that right? And Jeff and I also have a personal relationship in some fundraising stuff, and I help them raise some money for Books and Belize. And Jeff is a huge proponent and donor to Books and Belize, and they've built schools and healthcare centers and all kinds of stuff. At first, I was like, man, this attorney's always gone. He's in Belize. He must love to vacation there. And then one day I realized he's not there on vacation. He's actually there giving back. So welcome, Jeff.
Good, thank you. It's good to be here. Yeah, we put about 400 kids through high school in Belize. So it was a foundation started by one of my law professors at Drake, and then my wife and I got involved and went down to Belize and met these kids and kind of fell in love with them. And David's good enough to help with our auction and just to toot our own horn a little bit. I've been involved in a lot of nonprofits and a lot of charity events and auctions and things like that. The last 3 years in a row, in one night in Des Moines, Iowa, we've raised $500,000 in each of those events. And that's why we now can build buildings on top of putting 400 kids in school. Anyway, I am Jeff Lamberti. I practice in Ankeny. Pretty much practiced there most of my career. I spent my first 5 years in a big firm downtown, and then got elected to, at first, the Iowa House in 1994. So I moved my practice to Ankeny and started very small, just myself and another classmate of mine from law school. We office shared and then ultimately created a firm that still is in existence today. So I've been practicing in Ankeny since '95. So I'm entering my 37th year of practice. I didn't think I was that old, but I apparently got that old somewhere along the way. I practice primarily in real estate, so real estate, both commercial and residential, and then obviously ag is a big part of our practice. I do anything business related, lots of transactional type work, and now as I've got more seasoned, I do a lot more estate planning and kind of have gotten rid of some other things that I don't want to do as much, and so I kind of limit my practice to those areas today. And as you might expect, when I grew up in Ankeny, and we were a pretty small town when I moved there in 1965. I think we were 3,500 people, and today we're 80,000. So whether you wanted to become familiar with ag law, particularly as affected real estate first, if you were going to practice law in Ankeny, you found out really quick that was going to become a very important part of your practice simply because of the growth that we saw. So a lot of traditional farmland that was in the middle of the city when I started practicing quickly became development ground. And so addressing all those types of issues, that gets you into exchange matters, obviously, and then I've always done the more complex estate planning. And that's just been something I've enjoyed, and so that fits very nicely into the ag world as well. You don't, as you all know, you don't have to have a lot of acres to all of a sudden have an estate planning problem that you need to work on and talk about. So I'll stop there. Oh, before I do, I have to give my normal Iowa bar disclosure that nothing will be specific legal advice because I can't do that without knowing any, I'd have to know everything about you and your issue and all of that before I'd give a lot of specifics. But we can hopefully answer, I don't know it all, but with 37 years, I've seen most. And we have seen a lot of problems together. It's amazing as you deal with ag land across Iowa You would think, we have actually very good land records in Iowa because we are an abstract state. So from that perspective, we have really good records. But it's amazing how many easements or access agreements never got recorded. They're just handshake agreements. They're just common practice that goes back 80 years. And most of the time, they don't cause us a lot of problems. But we had one that I'm shocked we actually got it resolved because there were so many parties, the one with the railroad on top of it, which if you've ever dealt with the railroad and tried to get them to do anything, takes forever. So we've seen a lot, and we can usually find a way to fix them.
Well, let's start there. So 100% for you guys. I got a couple of coined questions to start with, but be thinking of questions. Raise your hand. I'm just going to bring the mic out to you. I'd like to record it, so I'd like you to put it on the mic if you have a question, and then we'll have Jeff answer it from there. If you want to be anonymous, you can scan the code and go there. Jeff, let's. One thing that we always get into is leases. So September 1st is when you need to renew your lease for farm tenancy. I bet half the clients I work with are verbal leases from way back when. And the clients we work with are the kids or the descendants or the beneficiaries of somebody that maybe had a lease in place with the neighbor. What advice do you have, is the question, for leases? Do they need to be written down? If we don't have them written down, should we? Where should we be with leases?
We prefer them in writing, strongly prefer them in writing. And we know there's a lot that aren't, and people have long-term relationships, and they can talk amongst themselves and verbally, increase rent when appropriate without a written lease. But it does create, as you get to heirs, it can create some real problems. So they're not hard to put together. I mean, we use bar forms. I can do one in 30 minutes.
Should we have the attorney do it? Should we go to the Iowa State one? Should we have a real estate company do it? Is there a best advice there?
Well, we always recommend your attorney do it. But it doesn't absolutely have to be. But they pretty much walk you through the main items, what you want, and because the way Iowa law is, most of our leases are 1 year. You can actually go beyond 1 year if you want. Otherwise, they're going to roll. And then the issue I have, and I have clients that are all over the board on this, some just let them roll and don't worry about, hey, should I be looking at the rent? Should I be renegotiating this? Maybe every 3 years, every 5 years. And then I have others who require me to give termination notices every single year. So they do that. They may then come back to me and say, we're just going to re-up the exact same lease we had, so do it with the same terms. But it gives them the leverage by terminating to renegotiate their rent if they want to.
And although it's terminated September 1st, most cash rents go March to March. So when you terminate that, do you ever terminate that with, we do, but I'm curious what your advice is. We always write in there, with the ability to gain access to the farm and do fall tillage. Because anytime we sell a farm, we have somebody that wants to come in and do fall tillage. That's the first question they ask. Hey, can we get in before March? We'd like to put anhydrous on. Do you write anything in there if you terminate?
Yes, you can write that into the actual lease.
Okay.
So when it's terminated, because the notice is just the notice of termination. Now, obviously, you still have to respect the rights of the tenant, depending on when we're at, where the crops are, that kind of stuff. And again, so we have people who want to negotiate every single year, and so we terminate. I think that's probably more than most people need, but if you really get to a point, even if you're rolling over a lease, even if it's a written lease we started and we don't do a new written lease every year, you pick your period, 3 years, 5 years, you want to talk about renegotiating that, you really should give the termination notice. That's your, if you're a landlord, that's your leverage.
So let's say that someone in the crowd wants to sell their farm, they forgot to do their lease termination, and now they want to sell it. This happens all the time. they can go and talk to the farmer and say, hey, can we list it? But technically that farmer can hold them to the contract, to even if it's verbal, correct?
Yeah, and so that creates it does create a lot of problems for us, because it depends, if somebody's very thoughtful and they've spent a year, 2 years contemplating selling, then hopefully that issue has come up and we take care of that up front. And so we make sure we're getting that terminated before we're listing it, before we're going to an auction, before we're doing any of that. Well, that's in a perfect world, and we don't live in a perfect world. That's usually not how it works. If at all possible, as you're thinking about, I may want to sell, even if you don't decide to pull that trigger, if at all possible before the September date, to terminate is best. If you don't, then it becomes a negotiation on how we're going to handle that. I mean, both with your potential buyer, so you can just go to the buyer and say, we've got to honor this lease. It's rolling over for another crop year. You need to be aware that you're buying it subject to. Well, what that impacts is the buyer's going to want the money, right? They're going to want the rent. So as a landlord, you just need to the extent possible, think ahead about terminating, or where you're at in a year with respect to deciding to move forward. And not everybody has that luxury of being able to decide that far in advance so that we can terminate, but also understand if we don't, because I certainly wouldn't hold up a sale if that's really where people want to go based on that, but go into it understanding what impact they may have on the overall sale on potential buyers.
And we just did one down in by Dexter that had a cattle lease on it from years ago, and it was the dad eventually gave the lease to the son, so it wasn't even the right lessor. And we sold the property and tried to get in touch with them, said, hey, we sold the farm, here's what it is. The guy never said anything until right about a day before closing, and then all of a sudden he wants to sue us. How do we avoid that?
Well, you avoid
if they won't answer the phone. I mean, what do we do if our tenant won't answer the phone? What do we do?
Well, if they won't answer the phone, depending on what date you're at, you just serve the notice. You make sure we get the notice served on them, because they can't deny the service. And we can serve these by certified mail, so we don't have to do personal service. And whether they choose to get it, pick it up, whatever, as long as we've got the receipt showing the mailing, that's considered good service on that. Now, in this particular case, I think people just weren't as aware as they needed to be about those dates.
Yep. Okay, very good. That was the softball question, because leases are pretty easy. You guys probably already know that. So we got another question out here. I'll just go out and we'll get that question. Hold tight.
So before we leave that lease situation, I'm just going to give you a scenario, and then you tell me where our risks could be. We have a farmer who does cash rent. We don't have any kind of contract. He just calls us. We call him. He's just down the street, kind of thing, right? And because we use the rest of the land, there's only a certain amount that's tillable, and we use the rest of the land for recreational hunting. We typically keep our cash rent very low, because we want to also have a conversation with him about what kind of crop we're putting in for the year to attract different animals. And so we don't have this conversation in September. We just kind of do it sometime over the winter, sometimes early spring. We don't get paid until the crops are in, and I don't know, I grew up in Chicago, so I know nothing about farming. So I don't know if that's appropriate, or if we should have the rent in our hands sometime when this fictitious September 1st date is. And so if we go to sell our farm, because it's so kind of loosey-goosey, kind of where is that risk for us?
So the first thing I would say, as to payments, we have a lot of farm leases that are single payments, and they are tied to the end of the crop year. So you're not that unusual. I like better ones where you get half up front, half at the end. That's probably more common today.
Okay, so when, when I said when the crop goes in, it's not at the end of the season when the crop is coming
Oh, so when
out.
it's all going in?
Yeah, we get paid in late May, whenever
Oh.
he plants the crop.
Well, then that's better than dividing it. Yeah, so that's fine. That's fine. So I'm not sure that you have a lot of risk. Now, whatever your rent was last year is your rent when it rolls over, okay?
Yeah, we've never changed our rent.
So-
We've had a couple of farmers, and we've done it for 20 years, and we've never changed the rent.
So
Right.
your legal risk, which I don't know is huge and could be remedied rather quickly if it ever became a problem, but the first thing that comes to my mind, so we know what the rent is, and it's not going to change, it's going to roll over. You say you have conversations with the farmer about what to plant, that you're interested in, what's good for habitat, for animals. Well, if the farmer decided, yeah, I know that's what you want, but I'm going to maximize what I can get out of that, you probably don't have a remedy to stop them because there's no writing. There's nothing in writing that says that's part of your lease. That's just been a handshake agreement. Well, if it ever did happen that way, then prior to the next September 1, we would terminate and say, guess what? Moving forward, those are going to be written terms in our lease.
We already did that with our last farmer. He decided he was gonna do it his way and not my way.
Then you negotiate, you get it in writing.
Yeah, okay. And so then what risks do we have if we decide we're going to sell the farm? Is it just really we're calling the farmer and saying, hey, we're selling, and now you're going to be dealing with Joe Blow instead of us?
Well, it really depends on where we are in the year, and that's what we see so much related to sales, whether they're negotiated sales, whether they're a listed sale, an auction sale. Where are we in the year? Because if we're in the middle of a crop year heading towards, let's say we're going to have a sale, I'm trying to pick a date, July 1, close date, July 1. Then we're really only dealing with partial, and we can deal with that in some fashion. I mean, depends on when it closes. So if there's not much time left, we can negotiate in the purchase agreement how we're going to split the rent. If the rent, now, makes it harder if the rent's already been paid because we might have to credit back. But other times, and this is where termination, if you can in advance of a sale, if you know it, so this is where it gets to be a little more problematic. So we don't terminate, we get into September, and October 1 you decide you want to sell. And we have a November 1 auction, or November 15, or whatever it is, with a late December close date. Well, first of all, we're going to need in that case to disclose to all buyers that it's subject to the completing that lease, and then you're going to just have to take that into account for all the buyers and how you're going to negotiate. You can start, for example, by saying, even though we're going to close this thing in December, we're going to keep all the rent for this crop year. You can do that, but it'll impact your price.
Got it. Okay. So the real risk there is whether or not we decide to keep the measly amount of money we're getting, or if we're going to give it to the other people.
Yeah, and in your particular case, because you're not charging a lot of rent, I wouldn't probably get too hung up one way or the other, right? I mean, you're negotiating over a fairly small amount, if negotiations is even necessary.
Jeff, since leases roll over year to year, we're past September 1st. If I sell their farm tomorrow, okay, as we're in the end of September, but they didn't serve lease termination, that farmer can still hold them hostage. I say hostage in that it's subject that he's going to farm it next year. And they might go to him and say, well, no, we're going to sell it. Dave's going to sell it for us. He could say, yeah, well, I'm still farming it, correct?
Yeah, once we pass September, they've got a whole nother crop year.
So that would be my risk for you, is that will that hurt the sale? If Mike wants to buy it, but he wants to farm it, guess what? If your guy bristles up and says, "Nuh-uh, I'm farming it," then Mike's like, "Well, I don't want to buy it now." So did we lessen our buyer pool? Possibly.
You may have. And the other thing you can do, if you're in that kind of time frame where you know you're past your September, but you really like to move forward with the sale, is before we put it up, before we had it listed, before we have an auction scheduled, you can negotiate with the tenant. You know, for example, we see this all the time in development ground. So we'll have a sale of development ground. Say it's 80 acres and it's going from being farm ground to be residential, but that developer is probably not going to start moving dirt for quite some time till they get their plan put together, all of that. They got city approvals, they got site plan approvals, they got all of this. So what they'll often do is say, we're going to honor that farm lease. We understand we're buying this subject to that farm lease, but they'll attempt to negotiate a payment for whatever crops they take out if they do decide that they're going to need to get in and start doing work prior to the end of that crop year. So it's a very similar kind of concept where you could negotiate.
Same goes with CRP. You can take ground out of CRP if you want to build a house, but you have to pay back the FSA office for whatever acres you take out. You can negotiate that at a later date. I know we got some farm managers and some trustees here. I was going to go down the route, a little tougher question here. We keep seeing in Des Moines Register, waterworks, Des Moines Waterworks, nitrates. As trust officers, as farm managers, as all that, this one's a lot deeper. If we rent the ground out, can we be liable as farm managers, as trust officers, as anything for some lawsuit with Des Moines Waterworks?
Well, and I'd be really careful on this one, and even after spending 12 years in the legislature, I'm going to be really careful. I would say, as the law stands right now, probably not.
Okay.
But things can change, courts can change, laws can change. I don't know what the ultimate resolution is there. I don't see that much willingness on the part of the legislature to make dramatic changes to the law, but you've got, obviously, if you live around here, you see Des Moines Waterworks is pretty aggressive. They're certainly playing this up for maximum benefit, and I don't know what the resolution is, but right now, I don't think, looking at it at least from an Iowa court standpoint, there's probably a lot of liability, but this is what plaintiff lawyers do. They get very creative and try to find a cause of action, tie it to, the deeper pockets are obviously the manufacturers, right? I mean, if you're going to go after something, you're going to go after the deep pockets. But if I'm looking at the entire watershed that feeds into Des Moines Waterworks, creative plaintiff lawyer, I bring everybody in. I got pretty deep pockets collectively combined. So, it's just one I monitor because I don't know where we're going with this. I'll be very honest. I don't know where this is all going.
If we're a landowner, and let's say we're Ankeny landowner, and we rent it to XYZ tenant, should we have something in our lease to say, hold harmless the landowner? If the tenant wants to put on 200 pounds of nitrogen, that's on them. We have them manage their own farm, or should we be protecting our own backsides?
It wouldn't hurt.
Okay.
So you could do it a couple different ways. You could, and I've seen this in leases where you talk about the conservation practices that you want, and it can be very specific or a little broader, where you can't exceed certain things without specific approval of the landlord, which from a landlord's perspective, I think does have a tendency to reduce your exposure if somebody went after you. Now, the problem that we get into ultimately is all of this is mostly governed by federal environmental law. And the federal law really tries to grab every potential responsible party first. So they don't like people being relieved of liability. So even if I go to, but you can do hold harmless. So, but understand, in the eyes of the feds, parties can both still be responsible. The hold harmless can help, but it only helps to the extent that the party you've got the hold harmless from has the ability to hold you harmless.
Because we could have trustee, farm manager, landowner that we work for, or land trust that we work for, and then the farmer actually doing the work, not including the company.
Yeah, and so
or the co-op as well. I mean, there'd be a lot of hands in that. I just make sure we're protecting everybody here, liability-wise.
yeah, and where a lot of this came from, it started with old underground storage tanks, where a lot of this law evolved. I happen to know a little bit about underground storage tanks because, as some may know, my dad was a co-founder of Casey's. So we got lots of underground storage tanks. And when they started to figure out we got to get rid of these steel tanks and replace them with the fiberglass tanks, the federal law and the state law regarding that really evolved fairly quickly. But one of the bottom line things to always kind of remember, if you were ever potentially the polluter, and that doesn't mean you did something negligent, but you own the land when the pollution occurred, you can't give up that liability. It'll haunt you and follow you forever, because the government wants to grab everybody. So they'll grab the next buyer and the next buyer and the next buyer. And that's why that issue is pretty much gone, because we've upgraded all of our tanks. But that's why we took it so seriously. We would not allow a transfer of a property without having a clearance of, it's called a no further action letter, to just say, as long as you've done what you've done, we don't require any further action. That's the only way to have the comfort that there wasn't going to be a tail chasing you for liability. And so we don't have law near as defined on other types of pollution. And so where some of this is going to go, I mean, specifically here in central Iowa, I don't know.
Gotcha. Looks like we got one. Keep getting questions, guys. Can you explain the process of establishing an easement?
I can. There's lots of different kinds of easements. The ones we run into mostly are access type easements. And they can be, I mean, the best way that they are done is by two parties who are in agreement that we need to do an easement, and then we're really negotiating about what it looks like, on whose property it is, because an easement can be entirely on what we call the burden property. So I'm giving neighbor an easement, but the only property burdened by that easement is mine, because that easement is contained completely on my land. Or it can be a shared easement where both are burdened. And then we're talking about maintenance, upkeep, that kind of thing.
I was just going to get to that. So this easement needs to be recorded to make it official, right?
Oh, yes. Well, no. Okay. So I would never recommend, if you have a need for an easement, to the extent possible, yes, they need to be in writing. It's just, as I said earlier, amazing how many are not in writing. And in large part, particularly if they're access type easements, we can enforce them if they've been used for 20, 30, 50 years.
That's called an easement by prescription, correct?
Right, and we can do it, but so you're going to spend 10 or 15 grand to get the easement that, if you'd done it in writing, might have cost you $1,000.
And that's saying that, hey, we've always done it that way. Grandpa did it, Dad did it. We all crossed right there. That's how we access the farm.
Yeah, and what normally happens on those, why we have to create a fight, as you've seen on some of these, is somebody, when the property goes to change hands and the buyer is wanting to confirm, or the buyer's lender, wants to confirm there's access to this property, and all of a sudden we look at the abstract and there's no written easement. So all we have is history. We've been using it forever. Then we really have to get into, okay, is there any other reasonable way to access that property? Because if there is, you don't necessarily get the easement even if you've been using it for 50 years. So what happens is, it's usually when there's a transaction involved, the neighbor all of a sudden says, that's not an easement, I don't agree to that, or it hasn't been used in 20 years, and those are facts questions that if we did, we'd have to bring an action for easement by prescription. And we ultimately can, and some of those, you know, a lot of times we just get into pushing back, right? And that's why I always try, when the neighbors try to negotiate these issues with me, it's like, please call your attorney. We'll get this resolved, because they'll know the law, and I'll tell them a lot of times, we're going to get the easement. If I have to sue you, I know what the outcome is. We're going to win. So how about we just reach an agreement and get this thing in writing? So that's a little off course, but what I'd say is in writing, if at all possible.
Would you suggest, so some of them I use, like Fox Strand and Associates out of Ames, and I actually get a plat that's a map that shows it's 60 foot wide, it's 50 foot wide, and it goes from this point to that point. Does an easement have to have a map with it, or is it just a written paragraph that you write as an attorney that says, Kevin can access my farm this way?
So unless it's one that is very easy for me to tie to a legal description. So if it's an easement that is the north 20 feet of the southwest quarter of the southwest quarter, well, I don't need a survey to identify the north 10 feet of that quarter section. Then it can just be in the easement itself. I've just described the easement area. Everything else, yes, it should have a drawing, which is done by, you know, a survey, an engineer, because it's going to help down the road when we all know exactly what. And some easements, you know, a lot of easements are very, just particularly access, are very straight, they're very easy, not a lot of complexity, but that's not always the case. We've seen ones that do this and they're all over the place. We need a drawing, and we need a legal description that goes, so we need an engineer or a surveyor to give us that.
As farm managers, landowners, trustees in the crowd, how wide should we make that? Do you have like what you're doing lately? You know, equipment is now 120 foot booms, and these combines are so wide. The old easements were like 20 feet, 16 feet. Are we 60? Are we 40? Are we 50 feet?
They should be larger today. Most of them are not, because people are thinking about the wheelbase more than right. And when you look at most easements that are in writing, but it's even true if they're not in writing, if we acknowledge there is an easement, we're prohibited from doing certain things, right? We're prohibited from building over the easement. We can't plant trees in the easement area, but I can plant it 6 inches from the easement area. So that's where widening them. Now, the hard part is the bigger they are, the less cooperative some neighbors will be.
If we want to get an easement before we sell, should we just offer the neighbor, here's $5,000, can we get this written down, Jeff will write it up and we're done? Or what's your advice? Do we just pay him the money and go in with candy and sugar rather than bristle up to him and say, we've always done it that way? Or what are your clients doing?
Well, it's all over the board, let me just say. And we've seen that it's all over the board, because if we truly believe we have a good easement, it's not documented, but it's an easement by prescription. It's been used for a long period of time, anything in excess of 10 years, but sometimes we have these that have been used for, 50, 60, 80 years. It's pretty hard sometimes to convince a client that spending money with the neighbor to go pay for what you already have is a wise choice. But when you look at it from the perspective of a buyer who may say, I'm not really comfortable that you actually have that easement, then it's probably worth the money trying to get it in writing and established. Because what we see, particularly Farm Credit and some of those, if they're not comfortable with access, they won't make the loan. And then that's what we spend our time fixing.
We held up closing for a year on that one.
Yeah.
A year, because Farm Credit wouldn't close because there was like 1 acre not documented.
And everybody agreed that this had been used forever. It didn't matter.
Didn't matter. Farm Credit wouldn't close.
Good. excited. Thank you. So I have a question about these easements in the respect of I have two questions. What if the easement is going to be used differently than it had been in the past? So in the past, it was a farmer went around and planted a little cornfield over there. But now, twice a year, right? I went in there, planted, and then went over there and harvested. But now it's going to be used to ride our Rangers, Polarises, and that kind of stuff to get there, even though there's access to the front half of the property. The ditches are deep, and you'd have to do some work in the ditches to build a bridge and stuff to stay on your own property. So what's there?
So if we don't have a written easement and it's just an unwritten ingress, egress, access easement, and if we all feel pretty comfortable that legally there is an easement, so we're not really contesting whether there is, it gives you full access. Doesn't matter if you're on your bike or on your combine. You have access 365 days, 24 hours a day. That's what an access easement is. However, if it's a written easement, I can do all kinds of things to limit what type of access. So, for example, I've done a couple on hunting land where we all know that's what the purpose is. Typically, it's got an out-of-state owner, or at least one. And I had one that was rather unique where it crossed 3 properties. They all agreed that there was an easement, so nobody was really trying to challenge that, but they were worried about truck traffic versus foot traffic interfering with the hunting. It took a bit of doing, but we came to an agreement ultimately about, we limited the amount of truck traffic versus foot traffic for the various parcels. So when you have one in writing, you can limit, as you know, because once the parties agree, they agree. So I can do a lot of different things in a written easement.
On the subject of hunting rights, since you mentioned that, if a cash rent lease does not address hunting rights, do the rights belong to the tenant or the owner?
You know, I'm going to have to say I'm not sure I know the answer to that question off the top of my head.
I thought it was the tenant, but I wasn't
I think
sure.
it is the tenant, to be honest with you. I think unless it's exempted out. So anytime I've had a landlord want to reserve back rights, whether it's a particular period of time, we've always exempted it out in writing. So I believe it is the tenant.
Just for your knowledge, hunting in Iowa, if you lease out your ground, I'm seeing $30 to $50 an acre for hunting rights, if you wanted to know the value of what the hunting might be on there. Everybody has a different program, but that's what I've seen is $30 to $50 an acre. We have a question up on the board. Do you have another question with that?
Related question?
Yeah. So is it, we have a, so is it just the land that you have leased out? You can't hunt on it, but you can hunt on the rest of your property?
Yeah, the rest of it's yours. Now, you can't shoot somebody's cow even if they're...
Yeah.
Back in the day, farmers always had the rights to hunt on that. And now, you know, unless the owner goes to them and says, hey, I'm hunting this, you know, don't think you're gonna rent this and hunt it.
Well, you know, and again, that's just another reason to have written leases and think about these. And maybe in a particular case, it doesn't matter and we don't need to. But even if we put a provision that just clarifies who has that right, and if it never becomes an issue, it never becomes an issue. But if it ever does, at least we've covered it. It's now in writing.
So this one gets a little more difficult. Let me preface this question. So for those that don't know what Section 180 is, Section 180 is a nutrient depletion write-off, taxable advantage to farmers where they can write off the nutrient value in the soil when they buy the farm. I'm told it goes back 15 years. So even if you bought a farm in the last 15 years, you can use Section 180. And you can write off the average that I've seen from my trusted resources, about $1,700 per acre. but it does lower your basis, meaning what you have in the farm, if you take that deduction. This question is pointing right to that. Thoughts on Section 180 legacy nutrient deductions. So that's what it is. Let's address that first. I did it last year, so I have a little bit of a clout in this. I went to my tax accountant, and you can take it all in 1 year if you just bought the farm. But she told me the code is written so vaguely that we're going to be very cautious and not take 100% deduction. She wanted to take it over the next 3 years. So example, if you didn't know about Section 180 deduction, on a 70-acre farm, we were able to use the tax advantage of about $130,000. But you have to make the income. So on Section 180, what's your thoughts on that?
Well, it's pretty complex because, quite frankly, it's really going to depend on people's individual circumstances. Because when we get talking about affecting your basis, then we're really more into estate planning discussions is really what we're talking about. And that is so specific to everybody because if you plan to hold on to the land, for example, till you die, and you know that, then take the deduction. Because quite frankly, I don't care what your basis is because your heirs are going to get a stepped up basis. So if you can get your basis to zero, so be it. I don't care. But who can tell me today that that's what they're going to do? That's the difficulty on that equation. Now, this is a bigger discussion, but I think it's important with the passage of the last tax bill and now having much more certainty around the issues of federal estate tax, stepped up basis not going away. I think we can do better planning now because last year we had, before they passed it, we had a lot of uncertainty about what was going to happen as we were looking at this cliff going to drop off. So depending on where people are in relation to the federal estate personal exemption amounts, which in 2026 will be $15 million per individual, so that's $30 million a couple. That can also play into issues of what we care about with respect to the basis in our property.
Let's talk about this, and I don't know how deep to go, and just tell me if you don't know. So if you want a little information, I actually have a flyer on Section 180 right over there that you can look. Also in the book on your table, there's information about Section 180. Some companies take the macronutrients, and some companies that we've worked with take macro and micronutrients. Some people say in the code you can't take the micro. Have you heard anything, or do you have an opinion?
No, we've seen so little of this, I wouldn't even dare to try to tell you I had enough knowledge to give you an opinion on that.
Okay, let's strategize this a different way. Let's talk estate planning for a second. And say I am going to buy this farm. So I spend $1 million on a farm. I get a $1,700 deduction on it. Okay, so it lowers my basis per acre, $1,700 per acre. And I take a $200,000 deduction, lowers my basis from $1 million to $800,000. If I decide to sell it 10 years down the road, well, I'll have, I don't know if it's recapture tax or it just lowered my basis, so now I pay capital gains. If I farm that currently, there's an exemption for the state of Iowa, so really what I have is capital gains for the federal. So I have 15%. So technically, I paid 15% on $200,000 versus if I just sold it and I took ordinary income and I was in a high tax bracket because I make millions of dollars, am I better to actually take the deduction and lower my basis, take a 15% capital gains tax versus take an ordinary income tax? Is one better than the other?
No, it's going to be very specific to your situation. That's a great question to set of circumstances to actually take to your CPA before you decide what to do, because very few people can tell me, and that's what the challenge is, I'm going to sell this property within 10 years. Some could, and if you could do that analysis. But if you literally don't know what the future is, it makes it a harder equation to figure out which one's best.
While we're on that scenario, so imagine this. You sell a farm, and I'm going to get back to the second part of that question. You sell a farm, you're the seller. And when you're the seller, you haven't collected cash rent yet. It's a big cash rent. Let's say we got $100,000 in cash rent on these farms we're going to sell. Is it better for me to take that as ordinary income for the trust that I represent? Do I take it as ordinary income because the tax level's here? Or do I put it in the closing statement and now it's part of capital gains because it raised the price of our farm?
So you mean in terms of just not taking it as rent?
Yeah, not taking it as rent. Tell you what, Mr. Buyer, we won't take rent, just give more money. So it made it look like we sold the farm for, I suppose it's scenario by scenario. It depends on what your tax bracket is.
It does, but you could, if you legitimately give up the right to rent, you could, and then take it on the purchase price, it will change your cap gain.
We've done that a couple times. Something to think about if you haven't thought about it. If you're selling, sometimes it's better not to take the cash rent and just get a better price on the property because different tax brackets again. One is capital gains versus ordinary income that you're taking as the whoever you represent.
And your CPA could actually fairly quickly give you advice on that.
So the second part of his question, and I'm not familiar with 174, thoughts on 174 research and development tax credits. I think this is if you plant something new every year and there's research and development credits.
Yeah, and I'm not either. And more importantly, without a little more specificity about what do you mean about specific thoughts on it. I mean, obviously, every kind of tax credit and things have good and bad, generally more good than bad, but I don't know specifically if they've got something more specific about that they'd want to ask.
And feel free to type it up there. I'm guessing I've had people just ask, is this legit? I've had people ask that on Section 180. What? I can write off the nutrient value in the soil?
So,
Yep. They're like, this has got to be. But I think it goes back to the Truman era, actually, when they wrote it in the tax code.
Here's what I will say. If it's in the tax code, yes, it's valid, right? And most of these have been tested through private letter rulings through the IRS, particularly ones that have been on the books forever. So yeah, you can take that to the bank that they're good and they're solid. Sometimes people will say this doesn't make any sense. That's the tax code. As I've become done more and more estate planning over my career, and had the fortune to work with some people that are smarter than me when it comes to estate planning, I learned about estate planning practices and tools and things available in the IRS code that have no practical justification for being in the code. They have no societal good. So when I say that, for example, charitable contributions, right? We allow a deduction for charitable contribution because it's perceived as doing a public good, right? So we tie the deduction to an outcome that we're trying to achieve. There are all kinds of things in the Internal Revenue Code that have one primary purpose, in my opinion, to make the wealthy wealthier.
Okay, I got a question.
And I could give you a couple examples, but it's probably off topic.
This Section 180, is this something new? And if it is new, do you have to prove what the nutrient depletion is?
You're probably better to answer
I
that
can
because
answer
you've
a
just
little
been
bit.
through it.
So a company that I used, no free ads, but Boa Safra is the company I used. They come out, they actually do a soil grid sample on your property. It costs $40 an acre. $40 an acre, and the average in the state of Iowa is $1,700 per acre credit. They get your macronutrients, your micronutrients. They make a whole report for you, and then they go back in time and they say, what is phosphorus worth at that rate that you have in there? What is your potassium worth in the soil? So NPK and all the micronutrients, and they put a value on all of it and how much load you have in the soil. And then they write you a full report to hand to your tax accountant and say, here you go, here's everything you need. We hired a company to do it. I don't think it's new. When I interviewed them, it goes back to like the Truman era. It's like back 50s, I think. I just don't think anybody brought it to the thought that you could use it that way, and now people started using it. The company told me that they had some people write off tens of millions So it's not just here I got $1,500, here I got $150,000. The folks that are using this are using it to the high level. So.
And those are the kind of things where we have something on the books and maybe people get creative and find something in the code that is legal but hasn't really been used in the way, and maybe it's just because technology and scientific is better today than it does. That could also drive them to change the law because all of a sudden people are claiming $10 million. But from a perspective of using it, until something changes, it's legal.
That 180 has to be done the year of the purchase, or is there any retro abilities?
I don't know the answer off the top
I've
of my
been
head.
told, so I'm going to regurgitate what I've been told. If you use it the year of purchase, you can write off 100%. You can go back up to 15 years from when you purchased the farm ground. So if you're sitting here like, I just purchased one 3 years ago, great, but you can't write the whole amount in 1 year. Then you have to depreciate it, and I don't know what the depreciation schedule is. I think it might be like back to the date you bought it, 8 years or 5 years. But you can't take the full amount in 1 year unless you bought the farm that year, is what I was told.
Because on page 15, I didn't understand.
Oh,
It was on page 15 of your book.
okay. Very good. Questions? What else we got?
But it has to be, you have to have somebody do a soil sample, the soil samples on it and make the analysis.
Yes.
To determine how much you can
Correct.
recoup.
Yep. Yep. Grid soil samples on it. You got it. If you didn't know about Section 80, there's a takeaway. How about what changed in the tax bill? Wait, we got one up here. Comments on Jeff's thoughts on how the big beautiful bill affected farmland and land purchasing and farming. So anything, I haven't dove deep into the big beautiful bill yet. Do you know anything related to ag that you'd like to pull out?
Well, given the kind of work I do, most of it's focused around the estate side and how it's going to impact that. We've talked about a lot of that, and it is going to change because of certainty. We now have certainty, and for most of my clients, not all, but for most of my clients, worrying about taxes have been dramatically reduced. So that's a good thing.
So let's break that down. I'm guessing that you're referring to like a state tax. It was 11.7 million. If they didn't renew that, then it was going to default back to 1 million when Trump changed it last time. What's the new level for?
Yeah, so starting in 2026 is $15 million per person. So if done correctly, a couple can protect $30 million. And it's not real difficult when I say if done correctly. It just means if you have an estate north of 15, but not yet 30, then we just need to separate assets between the spouses.
So let's talk that. How do we separate that? Do we have a trust? Is it David Whitaker tenants in common with Ann Whitaker tenants in common?
It can be a lot of different things. My preference is yes. I mean, so let's talk just briefly. I'm sure everybody's heard about revocable trusts. Others call them living trust. I think revocable is probably the more common term today. So revocable trusts don't protect you from taxation if there is tax. They don't shield assets from creditors, because if you could do it that easy, we'd all do it. Primarily keeps you out of probate, and that's the goal. Well, why are we trying to stay out of probate? We're trying to avoid the cost of probate. And the cost of probate is roughly 2% of your combined estate. Well, today, anybody that's got assets of $500,000 or more should have a trust. So that's the easy question. Yes, and if you're over $15 million, you should have two trusts. And so we use the trust as the mechanism to divide the assets. We still have to assign or transfer assets to each of those trusts. And it can be as simple as we could take your house and we could have half of it owned by one trust, half of it owned by another trust. We've got 10 parcels. We're going to assign 5 to this trust, 5 to this trust. I'm not worried about how many parcels you have. I'm worried about values. And so I don't want, if I have a couple that's pushing, say, $25 million, I don't want either one of them getting close to 15 million. So I'm going to try to do the best I can. Now, if you get an estate over $30 million, we have a whole different set of issues that we can talk about, other strategies to reduce and other strategies we may do during lifetime. But at the end of the day, you may pay a little bit of, or your heirs may pay a little bit of federal estate tax. And if you got an estate over $30 million, there's worse things in the world than paying a little estate tax, right? But there's also strategies that we can do. So the $15 million, the fact that it's been made permanent because we were dealing with uncertainty, significant uncertainty, and the fact that the stepped up basis is not going away. Those two items are they outweigh any, in my opinion, they outweigh any farming practice code provision by 100 times.
And so that value comes from an appraisal probably somewhere. I'm going to switch mics with you and change your batteries here quick. So 1,000 acres at 15,000 an acre, we're hitting that 15 million mark. So if we're pushing on that 2,500 acres, we're pushing that limit for that. What's the best way to, with the new big beautiful bill? Okay, we got a new limit there. We'll go back to that in a second. But for the kids, if I'm going to gift it to somebody, or they're going to assume the farm, do I start like an LLC and start giving them shares as soon as they hit a certain age? Do I split it and put some in their name and then, or create different trusts? Or what's the best way if I have 2,500 acres and I'm at 25 million and it's going to go to the next kid and they're going to farm?
So that's one thing that this has created, some interesting questions or interesting analysis depending on where people are relative to that 30 million. Because if people are under 30 and we've divided assets, so we're not worried about anybody bumping over 15, and say we're at the 25, and if they don't have a reasonable expectation to exceed 30, well, you can gift if you want, but there's no real tax benefit in doing so. In fact, there may be a tax detriment for doing so.
Because if they wait till they die, they get stepped up basis.
Yeah. So if I gift a farm tomorrow at 12,000 an acre, and when that person who made the gift dies, it's 18,000 an acre, well, the person who was the gift recipient now has capital gains that they wouldn't otherwise have. Now, I will say that's a part of the equation. That's certainly not the end of the answer, because there may be other reasons to want a gift during your lifetime. If you're over 30 or likely to exceed 30, then we need to kind of think about an analysis. So the maximum amount you can shield from federal estate tax is that 30 million. So if you're likely to exceed it, it's like, okay, how can I maximize what I get to my heirs before taxation kicks in? So that might be a gifting during your lifetime, and I'm going to take an extreme and just say we're going to gift all $30 million of farmland, and that oversimplifies everything. We're going to gift it to our kids today.
When you say kids, let's say there's 3 of them.
Divide it up.
Okay, so there's a difference between equal and fair. What do you think if one kid operates and is the farmer, and the other 2 kids work as an attorney and a banker? What's fair? What do you see people do?
All over the board. It really is all over the board. It's all over the board, from first rights of the person who's doing the active farming to buy the others out, or special provisions. I've seen first rights at less than fair market
Like
value.
70% of the value.
Right,
I've seen that a
right.
couple times.
Those are ones, whether we do a traditional will or we do a trust, if we're not going to do it during lifetime, so we're talking about passing it through a trust or a will, those are just individual discussions I have, and we try to tailor the wishes of the people. But from a value standpoint, if I think a couple's going to exceed 30 at some point in time, and they're worried about maximizing the amount that they can give without kicking, federal estate tax, then I might have a different discussion with respect to gifting during the lifetime, and here's why. We talk about highly appreciable assets, and often we're dealing with them in like closely held companies, or like in my family's case, of stock that is publicly owned, that over time is likely to appreciate. So if go back to the farm example, and I'm oversimplifying, but let's say you're well over the 30, but we're going to take $30 million of farmland, we're going to gift it to our kids. We've maximized our federal estate limit. So if that ground is likely to be highly appreciable over time, excuse me, everything that goes up in value from the date of the gift to the date of the second passing is additional value not subject to federal estate tax. Subject to capital gains tax, but it's not subject to federal estate tax. So you just moved out the $30 million value and all the growth before death out of your estate. So that's what starts, it really now is going to be very specific, I think, much more about where are you at in relation to those numbers and dividing that may impact, because again, at that base level, from a pure taxation standpoint, it's better to inherit than to have a gift because of the stepped up basis.
Okay, and we got to have that written down for them to do it. Let's go back to Corey's question here. I don't know if it's Corey's question. I just assumed because it's written like he would write it. Anonymous wrote it. So land purchasing and farming. New tax bill. I know of one difference in the new tax bill, and bonus depreciation came back. So a lot of farmers use 179 deduction to write off equipment, but this year we have a bonus depreciation, and I think it went up in level. Didn't it go to like $1 million or something? Like I
think it did go up. Yeah.
We can write off a whole combine now as all in 1 year. If we have a really good year, we can bonus depreciate. Is there other things or your thoughts on buying land, selling land right now because of the bill?
Not so much. I mean, some of those things like the depreciation are more operational, and those are good things. I mean, I think, it's really tough right now, right? Because nobody wants to buy equipment even with you still got to have the money to buy it, right? So we're not seeing combines flying off the floor right now. And so what it also shows is the tax bills and the tax code can't solve everything, but hopefully over time. But over time, that is a huge benefit and should have a positive impact down the road. I don't really see much that's making an impact on people's decision about whether or when to sell. Again, I think it creates some more certainty around estate side, but if we're talking about people, either I've already inherited this land and I'm thinking about it, I mean, getting rid of uncertainty would help if you want to be a seller, but I don't see a lot that's really impacted the market one way or the other.
Questions?
This one, you probably want to charge for service fee or talk about later. If somebody had a trust, the parents did, and there were brothers who were renting the farms on a cash rent basis, and the trustee ultimately becomes another sibling and becomes aware that the brothers have been paying below market rent. How do you address that? Not so much on the go forward, because it can be addressed if the leases have been terminated, but is there any suggestion on equality or equitableness when mother needs or the funds?
Well, if mother is still alive, that creates a problem. I mean, if mother was still alive and somebody could bring it to mother's attention that, hey, this rent was 40% below market, and that worked to their favor and not to the favor of the non-farming, and maybe you ought to consider some amendments to your will or trust to take care of that situation, that could be done. After the fact, probably not, because basically the way the law is going to look at it, mom allowed it. Mom was okay with it. And mom didn't change her trust, which I assume is an equal division at the end of the day because of that. Now, going forward, the new trustee who steps into mom's shoes has full authority to say, I'm going to get fair market rent because I'm a fiduciary and I owe that duty to the trust, to do that. Now, they could also, so if there were 3 siblings and they also agreed that they were going to bump it up to 90% of fair market value, they could always agree. But as a trustee, you're supposed to be a fiduciary.
If you're, brought up a question in my mind, if you're a fiduciary for a family, so I and my 2 brothers, they live outside of town. So they hired me to manage and take care of the rent, the negotiations, the attorney work, the everything. And I decide to charge for my time. What's the average that somebody charges to be the person? And they might get a little bit of administration fee. Is there an average?
There's really not. I mean, the thing you could look to is there's not a lot of banks today, but there are still several that have trust departments that will serve in a trust capacity. That's probably the closest thing to what you're talking about, basically being a trustee. But there's no hard and fast rule, but that'd be what I'd probably be looking to compare it to, or reasonable hourly rates for other professionals, whether they're financial professionals. A lot of people don't charge by the hour. You have to be in my profession to charge by the hour. But somewhere in that range.
Other questions? I got all kinds if you guys want them, but I don't want to lead it. If you got questions.
Okay, the situation that I'm in is that my in-laws actually set up a K1 Corp for farms. Okay, now they're both deceased. They had 5 kids. Out of the 5 kids, 3 of them are deceased. And they're getting near retirement. And a lot of the shares that the original people that started the corp had went to the grandchildren. So now the grandchildren want to sell the shares so that they can get the money out of it. Where does that leave me when, like, if they decide to retire, quit farming, maybe they're trying to decide, do we sell the farm? Do we cash rent it? If they sell it, what kind of effect is that going to have on me?
So several questions to maybe try to hone in. Who are the officers of the corporation?
They're the children.
The original children?
Yes.
So obviously, as an officer of the company, you have duties to your shareholders. So, for example, if somebody decided to stop farming and was currently farming, at least for the meantime, then you better come up with a plan with what we're doing with this farm until we figure out what we're ultimately doing with this farm, because you have a fiduciary duty as a officer of this corporation to make sure that happens. On the bigger scale, this is ultimately what leads to sales. And the law somewhat leads to this conclusion eventually, which usually results in sale, because the law does not like people governing from the grave for too long. That's why Iowa doesn't allow perpetual trust, for example. They don't like, and it becomes impractical. And usually what happens is just that. It can often just be one heir who's detached from the land and is more than one generation from the owner, the original owner, that says, I want my money. And beyond that, I don't really care. I just want my money. And you're going to figure out how to get me my money, or we're probably heading down the road of a partition action or something similar. It's a little different if it's held in the name of a corporation, but not so much. Now, does that corporation have any buy-sell provisions if somebody wants out?
I don't think so. Well, okay, here's another problem is the original children that have passed, you now have their spouses who inherited their shares.
Right.
So
You're
kind of the black sheep in the family.
It's just even more difficult to,
Oh, yeah.
and if there's no buy-sell provisions, then it's really subject to negotiations. I mean, it may ultimately, maybe the easiest and best is to just sell. But if somebody really wants to retain all or part of, well, you're still free to negotiate, right? You can still buy one or more of the other shares out. Now, sometimes that's not practical depending on how land sits and can be divided. And if you don't buy it all, it's really not workable.
So basically, you're talking about a buyout
Right.
or sell it.
Or sell.
Okay.
And then typically, personally, the other consequence to you then is capital gains. What was the value when you received it?
So this is our number one client, is somebody that kids wants the money. If that son or daughter or somebody or nephew or niece or whoever down the lineage decides to sell, they have to have a certain amount of equity. Isn't it 25%? They
No.
can't force the hand of everybody to sell unless, I thought Iowa rewrote the law.
No, not really. You
Really?
can still force the sale.
Okay, I
Now,
thought it had to-
there's differences between certain types of property, how long it's been in the family, and what ways that those partition actions proceed, but you can basically get out.
So let's say, and in your scenario, you're a K1 versus a lot of folks that I have are just tenants in common and with undivided interest. We don't know what acres you own and what acres you own and what acres you own. It's just undivided interest. What's the difference between undivided interest and they set up a K1? Is there any difference in his scenario?
Yeah, there can be a difference because the action could look a little different but end up in the same result. So as a minority shareholder, the officers owe a duty to you of fair dealing. And if you can make an argument that the fair dealing is not continuing to hold on to this land, but the best is to sell it, you can bring an action under corporate law to dissolve the corporation.
Okay, and for those that don't know, I work with Jeff on that partition action, where we've got to it where if the family can agree, more often than not, take that deal. Take the agreement rather than going to court, because the last two we were in were a year and a half, 2 years.
They're lengthy, and we try to discourage partition, although, I mean, we did 2 last year, so, I mean, we do them. Because you're at the mercy of a referee and others, and you know, it's not as simple as we have 2 people, we own 80 acres, we're each gonna get 40.
Yeah.
Nope, that's not how it works. They look at every acre, the quality of every acre, and if it's more complex than that, we've got 180 acres and we got 5 beneficiaries, and how are you gonna divide this up? Well, we really can't divide it up equally, so we're gonna start dividing it unequally, and then we're gonna have these OLTI payments back to one, so somebody's gotta come up with cash in their pocket to pay off one of them. And oh, by the way, you all don't get to decide this. Who's paying who?
The judge does.
A third party gets to decide all this.
Yeah.
So the risk typically outweighs the benefit of going through a partition, but in some cases, like the 2 we did, we had no choice.
They hated each other.
They hated each other, and there was no resolution beyond partition. Now, as it turned out in that particular case, we got a very good resolution.
Yep. So a couple things with this on the real estate side. I said this is our number one client. Jeff said transparency. So you have to be transparent, reasonable, that we got a reasonable price for it. People ask, why would we go to auction versus a listing? I suggest an auction sometimes because if you're the fiduciary, if you're the trustee and you're like, hey, I just represent the estate, I represent the K1, the whatever, I don't want my brother pissed at me. And they're like, well, I read on Facebook I can get $30,000 an acre. And I read over here that the tenant should get it first at 70% the value. How do we make sure it's impartial? Transparency of the auction when we go public is my number one reason to go. Is the neighbor had a chance, the investor had a chance, the tenant had a chance. Everybody had the same fair chance with the same terms and conditions. A lot of people think auctions, they think divorce, dissolution, disagreement, death. They think something is wrong because the 80s taught us that when the bank forecloses on us, we go to auction. Okay, that was a solution. But I'm going to argue that auctions bring the highest price, not just bad scenarios. Actually, the highest prices I've seen in Iowa came from an auction, not from a listing. We didn't even know we'd get that price. So we have all kinds of questions behind you. Did that answer your question first?
If somebody in an S corporation wants to get out of an S corporation, and they have tried to get the shareholders to agree on a Section 355, how then do they get out? It used to be by a letter. But they don't do that anymore.
No, and I'd probably need to know a lot more about the specifics in the history, because there still are mechanisms potentially to get out.
Other questions? The top, you have seen a lot of successful businesses. What have been some of the most successful farm-adjacent businesses to other farmlanders? So what they're asking is farm-adjacent business, like real estate, but we farm, or seed dealer, but they farm. What's been your most successful that you've seen guys do with farming?
Well,
Because farming doesn't always pay.
no, well, and there's quite a few actually, and fortunately for about the last 10 or 15 years, I've dabbled in private equity investing through one formal private equity group. We're called the Ankeny Angels, which is very similar. There's other angel groups, and then I've done some privately. Quite a few of those are ag-related, and what I would say is there's still great opportunity for innovation and technology in the world of agriculture. And those businesses, a lot of them are happening right here. I mean, they may be a very small seed business right now, but watch them, because I think they're going to have the potential. I didn't invest in this one particular company, which is doing some really interesting things with pollination, and as it affects the seed corn companies, so they're not dealing with farmers, they're dealing with, that's got the potential to, like, I mean, if you just think about a 10% increase in pollination rates, and that's very low, what that can mean in the number of acres around the world. And that company's being developed right here.
Right here in town, yeah.
Right here.
Not too far
So
away.
I see a lot of that. I mean, I had a client who started a company, he and his wife, and they really started off cleaning city sewers and things like that, that technology. They saw where ethanol was going in Iowa, and they got into the cleaning aspect of it, but they also developed their own technologies for how they could keep an ethanol plant fully operational while they cleaned it. So think about that. Normally you'd come in and you'd be out of operation for like a week and no production. And they found out a way to keep them in production while they cleaned. Well, that company ultimately sold for $10 million. And it was literally a mom and pop business when they started. To their credit, they held on to 10% of the company when they sold it. And 10 years later, almost to the date, the company sold for $100 million. So they did quite well. And so it's, you know, there's still opportunity for those type of businesses here. We have smart people here. We may not be the biggest state in the world. We have smart people. We just lack sometimes the capital. And that's what some of these groups are trying to change, so that we have groups, and almost all of these, and even the bigger ones in Des Moines, are really seed-oriented, early money, because that's the hardest money. It's the biggest return. It's also the biggest risk. And where, you know, out of 10 deals, you're probably going to lose your money on 6, but that's where you ring the bell, and that's where you go. And
so that's maybe the landowner or the investor. Do you see any successful farmers doing something on the side, like what those businesses are? Trucking or hogs or
yeah.
livestock? I mean, right now cattle are on fire.
Yeah, and we've seen that, and I think it continues in those. A lot of trucking, just providing services to other farmers that other farmers then don't have to do, because you want to scale some component of it. We see a lot of that.
You just made me think they all marry nurses, so they get the benefits of health insurance. Maybe we'll come back to health insurance, and carbon credits got in my mind too when you started talking ethanol plants. The next question up here is, what's one of the biggest mistakes that, what are common mistakes that families make when planning to transfer to the next generation? What do we need to avoid?
Probably the biggest mistake I see, first of all, I don't know, sometimes mistake is almost too hard a word. So we look at situations like yours, they all of a sudden get really messy, and then we look at, but you can't govern from the grave, and so what can you do? It's kind of in between. It's trying to be very thoughtful about the issues we talked about earlier, like, okay, what if one child is farming? What's reasonable? What's fair? Is not thinking that through. And we're not always going to come up with a perfect plan, but having a good estate plan takes some thought and energy. It's not real hard, I mean, but it needs to be done well, and that requires some time and some thought and discussion. It's just not having a good plan. Now, the biggest mistake is having no plan and having $20 million of assets that we haven't separated. That's the worst mistake, and you'd be surprised there are people like that. Because I will tell you, there is a phobia in the population, it's very small, that believes if they complete their will, they will die. It's real. I can tell you, we've got several wealthy people we've done drafts for, and we can't get them to sign them. And it's a great frustration for us. And I even tell them, in 37 years, it's never happened. I've never drafted a will, had people sign it, and then they die shortly thereafter, unless they ask me to come to the hospital because they were dying to do a will. And then that happens. But we can't. So not having a plan is the worst. Mistakes otherwise were mostly related about taxation. And quite honestly, most of that's gone away.
Okay. What do you got next there, Callan? What rights do farmland owners have if the government or utility companies want to use eminent domain for pipelines, roads, etc.? So carbon pipeline wants to come through. What rights does the farmland owner have? Solar's different. They may buy it or rent it or lease it. But
So eminent domain is really focused on the type of project. There's different types of projects that have different level of rights for the government. And of course, then we deal with things like pipeline, where it's not really the government, it's actually a private entity attempting to use under the authority of the government. So let's say the simplest one, not simplest, but one that's easy to get your arms around, roads. So the city wants to put in a new road, they want to expand a road, okay? Well, they have full authority to take your land. So the question when you come to me and say, hey, I got contacted by the city, they want to take part of my land to widen the road. What are my rights? Well, your rights are to be adequately compensated. That's it. It's not an if question. They will take your property. They do get to take your property, but you get to be adequately compensated for both the land they're taking, if they're taking out trees, if they're doing that. Now, we can argue around the edges about restoration of property, but those are minor issues in the bigger scope. But the thing to understand is they have the right to take it. Now we get to these more complex, and I could argue politically in different ways. I could argue for pipelines, carbon pipelines, I can argue against them. And I could give you my arguments on both sides. Right now, it's a moot point. The Iowa Utility Commission said they can use eminent domain, and the Iowa Supreme Court upheld it. End of story. So the only thing we're fighting right now is they want to change, from what I'm hearing, and I don't follow this every single day, they want to change their route, and it's still tied to what South Dakota, so South Dakota put a huge wrench in the original Summit Carbon Pipeline plan, but apparently, despite South Dakota, where they stopped it, they still think there's enough economic value to go forward with that pipeline, but as a result, it's causing some changes. So the opponents think it's maybe going to create another bite at the apple before the Iowa Utility Commission, because they have to get approval for a route change. And so I don't think, unless there's a dramatic change in the commission, I don't think that's probably going to be successful, but that's where that is. Otherwise, we're back to the same thing. I mean, on most cases of eminent domain, there's some things where we can argue, uses and is it appropriate? And that was what this case was about. So if you think about it, when we're talking about a city, a county, a state building a road, that's much easier for most people to get their arms around that, yes, the government has to have that authority. Otherwise, how could we ever build a road, right? I mean, we just couldn't. So giving them that authority, and then it's just about adequate compensation, that makes sense. You could say the same thing about water, sewer, power, those kind of things. Then all of a sudden we get into this thing known as a carbon pipeline. So what's the societal benefit, and does it raise to a highest level as the equivalent of a road, water, electricity, gas? Well, it was a question of first impression in both the Utility Commission and the courts, because we'd never had that issue before. We have pipelines, and other pipelines, if they're hauling petroleum, natural gas, those things have already been deemed that the government has full authority to use eminent domain for those pipelines. And that's why we have miles and miles and miles of gas pipelines under the state of Iowa. But we can make an argument that homes need electricity, homes need gas, vehicles need petroleum products. Do I need a pipeline that captures carbon and then transports it somewhere else? So that was essentially the argument before the Utilities Commission, is this is not either an essential or even a necessary corporate purpose we talk about, because where's the societal benefit? Which I found, and this is just me being a politician, I found it very interesting, the arguments, because somehow the original proponents of carbon sequestration talked themselves into a circle and I think hurt themselves. So for years and years and years, they told us that because of environmental concerns, being able to sequester carbon was a good thing. Same people who opposed the pipeline told us that was a good thing, that we need to do this from an environmental perspective. They loved the idea of carbon sequestration until a capitalist figured out how to make a lot of money on it through a pipeline.
Yep.
So if I'm arguing at the Utility Commission on behalf of Summit, which I didn't, I don't represent either side, I really don't have strongly held feelings either way. Thank God I'm not in the legislature, I don't have to vote on this anymore. That would have been my argument. Well, you just spent the last 10 years telling us we're all gonna die if we don't start doing something about carbon. Literally, you've said we're all going to die. So how can this not be an essential corporate purpose that eminent domain can be used for? End of story, you lost. Now, far more complex at the level of the Utility Commission, but at the end of the day, that's what happened.
Interesting. Yeah, arguments on both sides for that. Of course, if corn prices goes up, land prices go up. I like that. So if carbon helps with that, I'm in. I'm in on that.
And I'm not sure we know. Honestly, I'm not sure I know if they'll get this built. And in full disclosure, I do have clients that are impacted by this, and we have not done anything yet. We've had them really pushing on us to sign the options, and we may end up doing that. But every time we think the issue has been completely resolved and we're just back to a valuation issue like we would on a road, then some new news comes out in the newspaper that they may have to go back to the Utility Commission. So now we're just kind of sitting back and waiting again.
So let's say somebody listening or watching here, if they're gonna get fairly compensated. Okay. Yep, they can take it. We can establish that. Now you're gonna get compensated. How do they determine that? So like I'm on the condemnation committee for Story County. So I get called in as a realtor to be asked, do you think this is fair and just? But normally they have an appraisal already done. And then we, a team of 9 of us, normally make a vote on it. The ones that I've been a part of that we say, yeah, we think that $18,000 an acre is okay for taking the new Highway 30. I've had them fight it even farther and make the comments like, it's worth going to court. We'll get more in court. What's your opinion there? Is it worth going to court, or do you take the deal?
It depends on what we're fighting over. So if I'm normally just fighting over the value of the square footage of the taking, Generally not, because the appraisals have already been done. And unless you can find an appraiser that's going to say, hey, this appraiser really screwed up, I mean, they missed something significant. If it's just over that, probably not. Where it gets interesting, and it gets really interesting in these types of, this carbon pipeline or any other pipeline that's running under crops, the easy part in the crop equation is the calculation of the damage to the crops and the lost crops. That's usually close enough that people aren't going to fight about. It's those ongoing issues where the compaction issues and all that, where there is not exact science. And so they'll come in and they'll say, we'll give you 100% of your crop loss in year one, and then they'll have a proposed sliding scale for 2 or 3 years, and I can't remember how many years Summit went out, to try to compensate you for some lost production due to compaction in future years. Well, that's a really hard equation to know, are they right? Is there, and so you could see some challenging on that. But what I will say right now, if you thought the issue was resolved and the pipeline was going to happen, which I'm not still at that point, but if I was, with what they're offering, both, they're first offering money for the option, then they're actually offering money for the actual condemnation, I would advise my clients to take it, because you're getting 2 payments. You don't have to get the option payment. They can limit you strictly to the condemnation payment. And what I've seen, they're pretty fair. The payments are pretty fair. But that's just my opinion after doing these for, you know, a long, long time. And how much money do you want to spend fighting? And, you know, none of these issues at the Utility Commission or at the courts were about fair value. They were on all the ways trying to stop the pipeline under Iowa law. But it wasn't about valuation.
I got you. This is totally for you guys, so I want your questions. If you thought of anything new, just flag me. We got another hour or so that Jeff volunteered his time. So other than that, we can keep asking questions on here. But do you have a question here? Yeah, go for it.
But you're the experience. What do you think is, where are we at with land prices going up, going down, and how do you think the tariffs are going to affect us right now?
Sure. So land prices, this will be repetitive for some people. Let me back all the way up to 2020. So COVID, okay? Go back to pre-COVID. You know, you'd see the Des Moines Register post something that says 7,500 an acre is the average, okay? At that time, COVID hits, we have this disaster, and Trump's in administration, okay? Farm economy was down. We have $3 corn, so low prices. We have swine flu in China. So just back up for history here. Now, we have the lowest interest rates we've ever had, 2.5, 2.75. You could buy farmland and borrow for it, okay? Trump issues a PPP payment for COVID, payment protection plan. If you have employees, farmers, anybody, then they collect it. He also gave a market facilitation program, MFP payment, okay? If you farm 5,000 acres, you got a handsome check, okay? Then all of a sudden, China gives us the biggest call for corn they've ever had. The flu ended. They want more corn. All of a sudden, we see our price go up to $7 corn. Okay, so we got large demand. Our corn prices go up. Ethanol's still good. We got extra cash flow, low interest rates, and because of COVID, not a lot of farmland on the market. So what happens? There was tariffs back then. What happens when there's uncertainty? Nobody does anything. Smart people just pause, and they're like, what are you doing? What are you doing? And they just don't do anything. And so it just slowed down. So we have no inventory on the market, so supply and demand's low. Lowest interest rates, money in the pocket. Now we got more money in the grain bins that we can sell. Just the perfect storm hit. Land shoots up 42% by Farm Credit. Okay, their numbers was 42. Realtor Land Institute was 41%, and we saw the same thing. Okay, so we shoot up. May of 2022 was the highest land prices that I've seen in my entire career. Okay, 2023, I'm wondering, are we going to go down? What happens? I don't know if we can sustain. 2023, solid, just straight. We still are hitting it out of the park with land prices. Interest rates start going up. Biden administration says we're gonna stop capital gains. We don't want that anymore. We're gonna take away stepped up basis. Everybody's getting nervous. Nobody knows what's going on. I really thought we were gonna go down. It didn't. It stayed pretty steady. 2024, so last year, the market went down about 6%. So from the high. So when every time somebody makes a reference, 6% down, from when? Okay, from the high in 2022, we went down about 6%. That's from the Realtor Land Institute. The Federal Reserve confirmed it, and so did Iowa State's survey. Those are all surveys. Those are asking people's opinions. They're not hard data. So they ask guys like me and about 170 of us across the state that sell farmland, what's your opinion on this? So it's still an opinion, but it's pretty close. We went down about 6% 2 days ago. So Realtor Land Institute does a survey every 6 months. So 2 days ago, not to 2 days ago, back up to January. So now we're coming into 2025. I had some tough sales at the end of 2024 because that market was going down. We had a couple that were no sales. We didn't get there. And we could just see it declining down a little bit. Then all of a sudden we get Trump in office, new administration, new rejuvenated energy. We're in 2025. We have tariffs. Okay? Tariffs kind of were like, well, I don't know what we're going to do here. Can we trade? So in the middle of that, war with Ukraine. Well, a lot of our fertilizer comes from Ukraine. Okay, so a lot of fertilizer comes from Canada. Now we have tariffs on that. We have breadbasket for all of Europe is Ukraine. That dropped it sharply for a little bit, and then it kind of bounced back, and it's just steady. So it's kind of steady, and I don't think the local farmers, local boots on the ground, care about the war with Ukraine as much as I've seen it, or tariffs. I don't think the Chicago Board of Trade cares about it as much. But now, coming to 2025, there's still uncertainty. So now I'm back to COVID levels of ground selling. We normally would have 10, 15, 20 sales coming into the fourth quarter, and I have 4. I got 4 right there. So we're not nearly as much land coming to market. So supply and demand. Now we have low supply. Guess what? The demand is back up, even though we're at 6.5% interest right now. So right now, fast forward all that past history to right now, I'm not bullish or bearish. I'm just steady. The market is steady, but it is very volatile in this. 2 weeks ago, we had a sale over to Jefferson, Iowa. Wet farm, low CSR score. It just didn't present well. Okay, highest price I get on that, $7,000 an acre. The same day over by Iowa City, one of my competitors sold for $19,100 an acre. The same day in north central Iowa, we sold a farm for $24,000. It was a seed corn farm. So how do we get 6,000 here and 7,000 and 19, a 15 in central Iowa near Hampton? So holy smokes. So we have volatility based on who your neighbors are. So if that isn't a call for get an estimate or an appraisal with a trusted land professional before you start. So the average right now today, $12,822 an acre is what my computer software says of all the farm ground. That's the good, the bad, the ugly. Okay, from hunting ground to pasture ground to the best tillable to seed production, even stuff that they want solar on. Add it all together, now the Des Moines Register should read 12,822. That's where it should be today. I think it's going to stay pretty steady because we'd have low supply. There is a lot coming this fourth quarter. As I've looked at all the auction companies that sell, all the real estate firms that sell, there's a lot of acres going to hit the market, and here it'll be telltale. The crop right now, so long-winded answer to your short question, of all the things that affect farmland, from tariffs, interest rates, commodity prices, local demand, all of them, I would weigh in commodity prices at 70%. So you could have tariffs going bad against us. You could have interest rates going bad against us. But if the corn price is good, the emotion is good. I say it all the time. Markets are emotion. So what is the market right now? It's whatever the emotion of the farmer is. If the emotion of the farmer is, hey, I have a banner, bumper yield out there that I was expecting 235 and I just got 275 bushel. Well, they feel like they got corn in the bins or jingle in their pocket. Their emotion's good. So the interest rates are bringing them down. Now, 82% of farms are paid for free and clear in the state of Iowa. If that number, there's a lot of old money and a lot of old cash. So what I've seen is this, and this is why you see it. If you watch the farmland market, what you're seeing is more sealed bid auctions or listings rather than a public auction. Why? A public auction, I need two of you. Well, if your farm's paid for and you have old money and you're ready to buy, great. Where at a public auction do we win? One bid over the underbidder. So if Kevin's my underbidder and he was using bank financing and interest rates were up, where did his max stop? Well, his max just dropped. You might have been willing to give even more than that, but his max dropped. So if I went to a public auction, you're one bid over the underbid. So what do you see all the companies doing right now? Listing, tell you what, takes $15,000 an acre. They just put a price on it, and then if you want it, you get it. So that I think we'll just see the way that farms are sold sell a little different. It's going to be more listings. You're going to see people, we've done it, more just ask what you want. Now in a trust situation or a receivership or an estate, when said we need to sell it, let it go, true price discovery, we go to auction. So long-winded answer, sorry. Yeah. Crop prices, boy, I'm not an economist on this. I would love them to go up. My break even this year was $4.15 is what it took, okay? We're still not there. I hedged to arrive, sold some grain at about $4.70, okay? So back, if you were on the market back in January, you could have sold at $4.70. Great, and I'm waiting for basis, but basis is still negative 30. We still have production costs, get out there, haul it to town. Guys might be at break even right now. 415 is about where they're landing. I don't think they're going to go up. I'm not an economist, and I don't study that or nearly as confident in crop prices. Beans, so if you don't know, I have a podcast as well. So we're Farm for Profit podcast. So if you listen to podcasts, we have this dynamic every week. Every week, a farmer, local farmer, Corey Hillebo, a past ag lender, now full-time podcaster, Tanner Winterhoff, and myself in ag sales, we talk about anything to be profitable in farming. So I get to interview somebody every week. And of the economists that I've interviewed, most of them are steady. They don't think, we're not going to $6 corn. So if that answers. Yeah. What else? Questions?
I'd like to know who asked if I'm going to practice law till I die. Yeah, I see
Mr.
that.
or Mrs.
I see that.
Anonymous.
No, I don't plan to practice till I die. What I'm actually working on is slowing down my practice and limiting it to the areas I really want to stay in, and estate planning and real estate are kind of ones that really fit nicely in my world, and I want to take more of my time and deal with my nonprofits and my philanthropy. So that's what I'm doing. I originally was going to retire probably in a year, and talking to my partners, they were much more like, hey, we just like you being here even if you limit it to a couple days a week. And I said, that's kind of a schedule that could work for me, because I like to have a work home. I don't work from home worth a darn. So I'm kind of slowing things, but I don't have a expected retirement date.
What other question you get?
Oh, and my successors would be my partners. Since we have a firm, that's the good thing about a firm.
Under Iowa fence law, what are the current obligations for landowners between neighbors, farms, and how are disputes typically resolved? So it used to be, rule of rights, you stand here, or whatever.
It hadn't changed.
Okay.
I mean, it really hasn't changed. The fence law still applies. Lots of people, particularly people where the suburbs continue to, well, maybe not even that, where they continue to move out and look for acreages, having come from the city or the suburbs, to then get the knock on their door from their neighbor who intends to, or already does have cattle on their land, and informs them that they need to pay for half of the fence that they're either going to put up or repair. And they call me and say, is this a real thing? And I go, yeah, it is. And so, to my knowledge, and I've done quite a bit in this, nothing has changed. You have it's very specific in Iowa code, and it's basically that. I mean, you get into details that you're basically responsible for half the cost. And it gets down to the type of fence. So like, a neighbor can't expect you to pay for a fence that's twice what the law requires. you only have to pay for your share of what the law requires, and the code's very specific about what that is. But fence law is a real deal, and I don't see it changing anytime soon.
Huh, okay. What other questions you got there, Callan? If two neighbors disagree over a boundary line, how does the Iowa law handle the dispute? What legal steps should a landowner take? So encroachment is the legal term for this. I'm encroaching on your property, or you're encroaching on my property.
Yeah, and we really have to take a real look at the specifics, because what's the encroachment? How long's it been there? How long it's been there is very important, because you can basically acquiesce in somebody's use of your property. And normally it's open and notorious for 10 years or more. And so it can be as simple as, you know, they started mowing 10 feet over on your property line, but they've been mowing it and maintaining it and doing all this for 15 years. Well, they've got a claim, and they would have to bring the claim that that's their land now. Now, other boundary disputes are really just, we need to go get a survey, because, you know, even in city platted lots in the middle of a town where we think when they built the houses they knew where the lot lines were, you'd be surprised how many of them, if you went out and resurveyed, how many of them are off. And so we do get situations where somebody inadvertently builds a shed or a garage or something over somebody's boundary line. In those cases, we try to negotiate a settlement of some kind or purchase a little bit of the land. But there's a lot of different ways it can end up in court, because it's really fact specific. It's what are we trying to assert? Are we simply just saying, you know, often these will arise where my neighbor informs me they're going to put up a fence, and I think, based on where their measurements are, that they're on my property. Well, then the best thing is to go to the neighbor and say, did you have a survey done so you know exactly where your corners are and where your line is? And I'll even have neighbors say, no, I just know where it is, I'm not doing a survey. Well, then I advise my clients, we're going to do a survey, because then I can stop it before I ever have to go to court, because then I've established a line. There's not any usage over 10 years. I don't have to fight all those issues. But ultimately, in order to resolve the boundary line, depending on what type of facts we have, one party or the other may have to go to court. And it's just a boundary dispute, and it's a specific action. But again, it depends on, are we asserting it by usage, or are we just asserting it by a survey, or is it an encroachment issue, and I'm asking you to take down your garage because it's on my property? So very fact specific, but they all kind of proceed the same.
One thing that we haven't talked about, which I'm surprised, is IRS Code Section 1031. So where we can defer our taxes down the road and kick the can, if you will, until we pass, and then we get stepped up basis. Is there any changes in Section 1031 that you see?
No, and nothing significant. And so it was another one of the uncertainties at certain points in time before they got the big, beautiful bill done. But right now, all 1031 should be the same. What I advise people, 1031 is a good tool, can be a good tool, depending on your circumstances. When we have a client that is interested, at least in central Iowa, there's 2 or 3 really good companies that are exchange agent experts. We like, I want to be your attorney. I don't want to be your exchange agent. I'm not the one that does that, but I connect, and we work very closely with them. For the most part, 1031s are like-kind exchange. So the easy ones is I want to transfer a sale of a farm for the purchase of a farm, or a commercial building for a commercial building. Inevitably, I have clients that want to get creative. And they want to try to somehow
Vacation home.
take this farmland, convert it to commercial property, because maybe it's development ground, and then buy that commercial building. And that's where I say, well, if you can convince that exchange agent that this works, I'll close the deal, because that's my job. But there can be some gray in there. That's why we employ good exchange agents. There's almost nothing they haven't seen.
So a reminder, 45 days to recognize, 180 days to close on a 1031, and that is from the day when you receive the money. So it's not the day of the auction. It's not the day that we sealed the deal. It is when you collect the money. Okay, the relinquished price is the day when you relinquished it or sold it and acquired it. So a couple of key dates there that we could talk about. Got a question out here, and then I got an interesting question up here.
So the scenario would be a farmer wanting to retire, 65 years old, got a young son that's coming into the operation. He wants to help. He has helped, but he's got you know, some money tied up in his equipment. He wants to transition the equipment to the son, mostly depreciated out. What's a good way to get the equipment to him? It's fair to both of them. He gets some value for it, and they don't have to pay a lot in taxes.
Well, because the seller, in what you're telling me, is not hung up on getting the maximum value for the equipment, just wants to get something fair. So anything you receive is going to be subject to gain, right, because it's depreciated out. But beyond that, there's really not anything preventing you from selling it for whatever you want. Whatever the two of you agree is fair. And, I mean, that may not fit your scenario, but that ties back in to a scenario of when's appropriate to maybe gift versus inherit. That could be an appropriate situation to make a gift. And so you may not really be worried about this whole 30 million, 15 million, all that, but you can still use your lifetime exemption during your lifetime. What you're supposed to do is, so let's say you had equipment worth, I don't know, $200,000, and you wanted, okay, fine, I didn't know I could gift it to my son, I'll just gift it to him. Well, you're supposed to file a gift tax return, claim the $200,000 against your 15 million, because then you're just showing the government that during my lifetime, I've used 200,000 of my 15. That might be an example. But otherwise, selling it, you can pretty much, I mean, there's no requirement for you to absolutely have to sell it at fair market value.
Is there a limit there? You know, X9 Combine's $1.2 million right now. So most farm operations, by the time we get tillage and planting and harvest and everything, they'll have an easy $1.5 million in equipment. So the numbers are just going to be a little bit bigger. If we're $1.5 million in equipment, can I gift it to a son for $20,000?
Well, if you were going to gift, I'd just gift it.
Okay.
Be done. Other thing that I forgot to mention, another thing would be a structured sale of some kind over time, and it kind of gets into a couple things. So if you do a note with a family member, which essentially is what that would be, just a promissory note to pay, so maybe I spread that equipment loan over 20 years or 10 years or whatever it works, you can do that, and that's another mechanism to make it easier. You can even retain a security interest if you really feel you need to. But when we look at the interest rates, the federal government has minimum interest rates that family members have to charge, because you can't give it at zero interest, or that is considered a gift. So the difference between zero, and they publish these rates every month based on the length of the note. So they have short-term, medium-term, long-term, and you have to charge minimum interest rates. And it's at the time you make the note, because it changes every month. And as long as you're at the minimum, they're pretty low, but they'll surprise you occasionally, and it'll be like, oh, I got to charge 3.5%. That doesn't seem, you know, like a great deal. But you can also do that.
That ties like right in, segue to this question here. A friend of mine was asking me this the other day, so they might be the one online looking at it. Should I have my wife or kid or successor put a lien first on my business? So let me give this scenario here. Whitaker Marketing Group. Let's say we're worth, whatever, $5 million, if that's the case. Rather than wait for a lawsuit that somebody wants to sue me, could I have my son or daughter put a lien, somebody I trust, put a lien on a first position on my business? Then when XYZ guy at an auction doesn't think I did it right and sues me, okay, well, yeah, even if you win, guess what? My kid has first position. And so he's going to get everything my company's worth, and there's nothing left for second position. Can you do that?
You can try, but I'll defeat that, because it's not real. And so it's much like, you've probably heard of things called fraudulent conveyances, where you try to get assets out of an entity. Somebody's being sued, they try to move out assets, and it's called a fraudulent conveyance. So they gave me their assets, they can come to me and get those assets. It's very similar to that because there's nothing real behind it. So there's no money no money had been loaned, no anything to be the consideration for that lien. And so sure, it would take some discovery on my part if I was a judgment creditor against you, but 9 times out of 10 through discovery that would come out. Because first of all, you'd put me on notice. You'd say, well, you can sue me all you want, but my kid's got a $1.5 million lien. Yeah. And I'm going to say, okay, for what? For what? What did you do? And then I'm pretty quickly going to prove that there's no there, and then I'm going to defeat that.
Got it.
There's no great way, and this is a good maybe general statement, and don't take it too extreme, but I think it is a good general statement. There's no good way through estate planning, through corporate structures, we can do things to protect assets, to shield personal assets, to limit liability, to do all those things that are perfectly legal to the extent possible. But there's no really great way to shield your assets from liability unless you give them away. So, people come to me and they maybe want to get assets out of their estate. If they're willing to make and not have them subject to like Medicaid down the road or things like that, if it's a true gift and you get rid of it and you give up control, we can make that work because they're no longer your assets. But not that many people can give away their assets to shield their assets. Otherwise, we do the best we can with corporate structures, with insurance, and all of those things to limit our exposure. But ultimately, we're all still at risk at some level.
Gotcha. Other questions? What do we got? Anything? I have a million, but I'm going to be respectful of your time. I think we're good there. Guys, I just wanted this to be an informal 100% where you can ask. Hopefully you got some value out of it. Thanks to Mr. Lamberti here for taking his time and coming out. Hopefully you enjoyed some food. And yeah, when you think of farmland, think of us.